Hi, and welcome to this latest immigration law update video. In this video, I wanted to look at the subject of deportation, very significant obstacles to integration, and the whole concept of exile in deportation cases. And I'm going to do this by looking at a new decision from the Court of Appeal called Lowe, and it's 2021 EWCA Civ 62, and it's from the 25th of January 2021. So let's have a look at this decision. This is a decision where the first tier tribunal had allowed an appeal on the grounds that there were very significant obstacles to the integration of the appellant back in Jamaica. The upper tribunal had overturned that, and the appellant appealed to the Court of Appeal, who found that the first tier tribunal's decision was not irrational, and the upper tribunal judge was wrong in finding an error of law and substituting their own assessment. So let's have a look at paragraph 2, actually. That's the first interesting thing, and that was the grant of permission to appeal by Lord Justice Holroyd, because he says it is arguable that UT was wrong to find that the decision of the FTT was irrational and wrongly substituted its own assessment of whether there were very significant obstacles to integration in Jamaica. And then he addressed the second appeals test. The second appeals test is satisfied because the seriousness of the consequences of the decision of the UT, brackets, acknowledged by the UTJ as amounting to exile rather than deportation, provides a compelling reason why an appeal should be heard. Now, exile, if you look it up in the dictionary, will mean being forced out, being barred from your home country. And effectively, they're saying, because this is a case of exile where somebody's lived here virtually all of their life and has no real knowledge of their home country, that's a compelling reason, and the second appeals test is overcome. So that's really interesting. Let me give you a summary of what Lord Justice McComb found, and that's paragraph 3 of his judgment. And he says this: having carefully considered the helpful arguments, and he gives counsel's names, I find the upper tribunal was indeed wrong to hold that the decision of the FTT was irrational, and that it was also wrong in substituting its own assessment of whether there were very significant obstacles to the appellant's integration into Jamaica after deportation for that of the FTT. Indeed, because the UT correctly determined that this was a case of exile rather than deportation, there we have it again, we'll come back to that notion, it expressed succinctly in summary form the basis for the underlying very significant obstacles to this appellant's integration into a country of which, in spite of his being one of its nationals, he had no past experience of any meaningful kind. Further, the FTT had decided the case on the basis of the case made by the respondent in the light of the evidence presented by the appellant in support of his claim in the decision letter and in argument. Having rejected that case on the evidence, it was right for the FTT to allow the appeal. The point there was the UT had relied on something in the respondent's case, which actually was wrong. The respondent's refusal letter was wrong, as we're going to go and see. So let's have a look at the background facts. Appellant and his parents, both nationals of Jamaica. Appellant born in 1999. His father came to the United Kingdom during his mother's pregnancy. In 2002, the appellant, who was 3, accompanied his mother to join his father. Parents were separated in 2005. Appellant continued to live with his mother, and both parents had further children. Appellant became subject to a deportation order because of a criminal conviction. The offence related to March 2017. It was possession with intent to supply of crack cocaine and possession of a bladed article. So it was a few weeks before his 18th birthday he committed the offence, and he pleaded guilty, full credit for that, and got 2 years and 4 months in the Crown Court. So the respondent decided he should be deported. Paragraph 399A of the immigration rules, which obviously mirrors exception 1 in section 117C4 of the 2002 Act, says this: foreign criminal has been lawful resident in the United Kingdom for most of their life. Tick, that was accepted in this case. The foreign criminal is socially and culturally integrated into the United Kingdom. Tick, that was accepted in this case. And then there would be very significant obstacles to the foreign criminal's integration into the country to which he's proposed to be deported, in this case, Jamaica. That was what was at issue in this case. So the respondent accepted those first two limbs were satisfied. There's the reasoning here in paragraph 9 why they didn't accept there were very significant obstacles. And again, there was this error that Lord Justice McComb points out, that it was taken that his father and his father's extended family live in Jamaica, but that was wrong. So the FTT decision is then set out, and the judge addresses this error in the respondent's refusal letter and finds as a fact, see paragraph 13 here, that the appellant's father is in the United Kingdom and the appellant does not have any family or other connections in Jamaica. It was also accepted that the appellant had never been independent. He'd always been dependent on his family for financial and other support. So he'd always been part of that family unit, never been independent. And that was accepted by the first tier tribunal judge. And then you see at paragraph 18, Lord Justice McComb sets out the summary finding then of the FTT judge, who finds, because of the length of time the appellant had spent in the United Kingdom, so since the age of 3, lack of any family or other support in Jamaica, never lived an independent life away from his parents or state institutions, lack of financial support, which would allow him to get the basic necessities, there were very significant obstacles to integration. The Secretary of State appealed to the upper tribunal. Obviously, the nature of the challenge was on that the decision was irrational or perverse, so not one that the first tier tribunal was entitled to reach on the evidence. The upper tribunal judge then is quoted, and he notes that the appellant, or who he refers to as the claimant here, had not shown that he made any attempt to sort out how he might live in Jamaica, or about employment opportunities. And also he speculates then that the claimant had somebody of sufficient wit because he was involved in a drug ring enterprise and cannot be regarded as a helpless babe. And he sees nothing that could be properly described as a very significant obstacle. And what the Court of Appeal say, Lord Justice McComb says here, is, look, in this case, he's making his own decision here. And effectively, what the judge gets wrong here is he's making his own decision rather than looking properly at whether it was a finding the first year tribunal had been entitled to reach, and he's bringing new matters into the equation and speculating about wit and helpless babe and the like. Because what Lord Justice McComb says at paragraph 23 is what mattered was whether the FTT judge was entitled to find on the evidence that he had seen and heard, and which the upper tribunal had not, and on the case made against him, that this young man with his characteristics and background would face very significant obstacles to integration in Jamaica. Now, the upper tribunal judge accepted at paragraph 31 of his judgment that this was a case of exile rather than deportation. But in this case, then, he sets it aside as irrational, the first tier tribunal, and remakes the decision dismissing the appeal. But in doing so, he relies on the fact, he says clearly the Secretary of State did not consider that there were, else he would not have made the decision in the first place. And Lord Justice McComb, paragraph 25, finds that strange because the respondent's own decision was made on a misapprehension of the facts, namely about Dad and the extended family being in Jamaica. So it was wrong for the upper tribunal to pray and aid the fact that the respondent had made this decision when the respondent's own decision-making was based on a misunderstanding of the facts. Both parties referred the court to the case in Camara. That's where Lord Justice Sales, as he then was, gave guidance on the notion of very significant obstacles to integration and said it's a broad evaluative exercise. And Lord Justice McComb, relying on authority, cautions that the Court of Appeal should be very slow in interfering, and appellate courts like the upper tribunal should be very, very slow in interfering with broad evaluative exercises when judges have had the opportunity to hear witnesses and see them give evidence. So paragraph 32, Lord Justice McComb says this: it was, in my view, quite open to the FTT judge to find that there were the necessary, very significant obstacles based on the impression made upon him as to the effect of the exile, there it is again, of this young man, with all his characteristics, attributes, and qualities and defects that were disclosed by the evidence. Not every healthy young man in a case such as this would make the same impression. However, this was a 19-year-old with a conviction when he appeared before the FTT. He had lived all but the first 3 years of his life in the United Kingdom and had no connection to Jamaica whatsoever, other than a residual nationality. The judge found that he had a specific dependency on his parents. The judge was entitled to form his own impression of the obstacles that he would face on being dumped in Jamaica at the end of his prison term. He was not an adult foreign criminal like some whose cases come before the courts with a significant foundation of knowledge of the country of his birth from an earlier time in life, and who is being returned to a country with which he has some acquaintance. It is not surprising to me that a judge, if not all judges, would find, as this judge did, that there were very significant obstacles to integration. Others may have made a different decision, but this was very much a case on its own facts to be assessed on the evidence. And then he confirms that the FTT decision was a permissible decision. It was a legitimate evaluation of the case, and that the upper tribunal was wrong and impermissibly substituted its own assessment of the case. Lady Justice Appellant agreed with Lord Justice McComb, but note Lord Justice Phillips dissented. So we don't know if there'll be an appeal to the Supreme Court, but certainly Lord Justice Phillips dissented in this case. Now, what I wanted to look at was this notion of exile, because this notion of exile actually goes back to a 2010 decision. It's HK Turkey 2010 EWCA Civ 583. And it's from this little concurring judgment here of Lord Justice Sedley. And he says this: if there is a gap in the tribunal's reasoning, this is paragraph 35, it is their apparent omission of the fact that the respondent had been here since the age of 6. The number of years a potential deportee has been here is always likely to be relevant. But what is likely to be more relevant is the age at which those years begin to run. 15 years spent here as an adult are not the same as 15 years spent as a child. The difference between the two may amount to the difference between enforced return and exile. Both are permissible by way of deportation, but the necessary level of compulsion is likely to be very different. Now, from what Lord Justice Sedley said in this case, we have the notion of the homegrown criminal. But in recent years, the Court of Appeal have really been depreciated the notion of homegrown criminal and really sort of squashed it and said it was unhelpful and potentially misleading. There's a case called Binbuga. It's 2019 EWCA Civ 551, considers quite a number of issues in this case, but did grapple with this notion of homegrown criminal. And they found, so here is issue 4, whether the upper tribunal judge erred in holding that the FTTJ made a material error of law in relying on TB being a homegrown criminal when assessing whether he was socially and culturally integrated and whether there were very significant obstacles to his integration in Turkey. And what the FTTJ had done in that case is rely on HK Turkey and this notion of exile from Lord Justice Sedley and said, well, he's a homegrown criminal. And in this case, Binbuga, they refer back to LW Jamaica, which is 2016 EWCA Civ 369, and what Lord Justice Gross had said in that case. And they entirely agree that the description homegrown criminal offender cannot withstand analysis. It is an unhelpful description and liable to mislead. Now, in Lowe, the case we've been looking at, they don't use the phrase homegrown criminal at all, but they use the phrase exile, and it seems that the tribunal judge accepted this was a case of exile rather than sort of deportation, which comes from Lord Justice Sedley's judgment in 2010. So whilst the notion of exile seems to have gone out of fashion, it may be brought back in following this case of Lowe. So Lowe is a helpful case and has some really helpful stuff in terms of the grant of permission and this notion of exile, and showing that the FTTJ's decision was not irrational or perverse and should not have been interfered with. So I hope that's helpful to you. Do take a look at this case, and what I will do, I will paste below the links to all the cases. Thanks a lot.